is intended to reduce the incubation period of lawyers. We had our first season of PCL, where we were talking about institutions, various institutions under the Constitution and our legal system. One thing that we found was that a student in a law college studies law, and how to study law is one question. With my experience and understanding about law studies, there are two things which is very important. One is finding the law during your law studies. You may be given a factual situation, and in that factual situation, you may have to find the correct law. That is first thing. Nowadays, finding the law is not a very difficult task, because you have various devices by which databases and various devices by which you can easily find the law. Once you find the law, as a legal professional, you may have to apply the law in a given situation. So you need to know how to interpret the law. So the second thing is interpretation of law. I believe that during the entire course, a student is expected to do these two exercises. One is finding the law, and the second one is to apply the law by interpreting it to a given situation. Once you become a lawyer, there are many more skills that you may have to acquire to have a good practice. Lawyering skills, hearing skills, drafting skills, and it has been identified that at least 14 skills are required for a successful lawyer. PCL is foundation intends to provide that extra element of training on various skill sets, and also to introduce law students to new areas of practice. It is accordingly that we come to formulating this program on arbitration. I am not aware as to whether you have studied the Arbitration Law of India, that is the Arbitration and Conciliation Act 1996. I believe that it's an optional subject in the LLB course. And understanding about arbitration is is very important in the changing world. What is its importance? You may get your LLB and you may become entitled to practice in the courts of law. A new scenario is being developed in the country. We hear that the economic progress of India is remarkable. That simply means that we are going to have more investments coming in. How do you have investment coming into the country? There will be a basic document called a contract. Necessarily, these contracts will be entered into between an Indian party and a foreign party. We should understand one thing. Whenever you have a dispute, whenever you have a contract, the necessary corollary is that a dispute is hidden somewhere there. So this dispute resolution in commercial contracts becomes one of the important area of legal practice. Now let us come to the question as to how you resolve the disputes in commercial contracts, especially when one of the parties is a foreigner. For instance, a person who is a citizen in China enters into a contract with an Indian party and a dispute has arisen. How are you going to resolve? Can you file a suit before the local subcourt? Will the other party in China submit himself to the jurisdiction of the subcourt at Ernakulam? Definitely not. He would say that I will sue before the Chinese court. So the question whether the Chinese court has jurisdiction or the Indian court has jurisdiction has to be resolved first. It may go up to the Supreme Court to decide as to whether which court is having jurisdiction. Even when you find that one court is having jurisdiction and the court passes a decree, how do you enforce it? Unless and until you have something like a reciprocity or a reciprocal arrangement with the foreign nation, you cannot enforce it. In this case, the Chinese party may be having assets in China. Is it possible that the Indian decree is going to be executed in China? Definitely not, because we don't have a reciprocal arrangement between India and China. That simply means that the Indian decree will not be executed in China, as Chinese decrees are not being executed by the civil courts in India. So, therefore, going the litigation route is of no use. What is the next option? The next option, and the only option, when you enter into a contract with a foreign country or person of a foreign country, is to ensure that you have a dispute resolution contract or a dispute resolution agreement included in the main contract. We call it an arbitration clause, and sometimes it will be a mediation plus arbitration clause. Whatever it is, arbitration is the only method by which such disputes can be resolved. Why is it so? It is so because 156 countries in the world have entered into are signatories to the New York Convention. You might have heard about New York Convention. The terms of New York Convention are included in our Arbitration and Conciliation Act 1996. It is included in Part 2 of the Arbitration and Conciliation Act. So therefore, the signatories to the New York Convention has agreed two things. One is they will recognize arbitration agreements, and they will also enforce arbitration awards passed by the countries who are signatories to the New York Convention. So therefore, you can execute a arbitration award in China, but you cannot enforce a decree from India in China. Likewise, India will enforce arbitration awards where the place of arbitration is in China, but India will not enforce a decree that is passed by a civil court in China. More importantly, If an arbitration award is passed in India, you can enforce it in 156 countries across the world. Wherever the assets of the defendant is, you can enforce it. So this course is more important because across the world, arbitration is the focus of the day. Now about this course. We are planning a 50-hour course where we will have 10 hours of interactions, 32 hours of study through our platform called Moodle, and 8 hours of assessment and assignments. Currently, PCL is working with the Kerala High Court Advocates Association, and we are training lawyers of the Kerala High Court Advocates Association. An arbitration training program is going on. We already had 2 interactive sessions. We are planning the 3rd session tomorrow at 4:40. Those who have registered can join the program that's on a hybrid mode. The lawyers are expected to come physically, and those who are the members of the PCL who have joined this course can join online, but a unique ID number will be given, and you have to mention that unique ID number in order to get yourself admitted to the online session. I think that that will be provided by Sanjay. I will share with you the syllabus. The first session has already been taken by a arbitration practitioner. His name is Mr. Anil Changrod. He joined us from Singapore, and he was discussing about arbitration in the ADR regime. According to him, ADR is not alternate dispute resolution, but it is appropriate dispute resolution, in the sense that arbitration is not inferior to litigation or any other modes of dispute resolution, but it is the appropriate dispute resolution. Of course, in international contracts, as I already mentioned, there is no other go but to go for arbitration in view of the enforceability through New York Convention. And we have also discussed a little bit about uncitral model law, and we have discussed something about English Arbitration Act. We will have a more detailed discussion tomorrow. And we had another session which was taken by Mr. Imba Vijayan. Imba Vijayan was discussing about, he is an international arbitrator. He was talking to us about party autonomy. These videos are will also be shared with you in the Moodle platform once you join. So tomorrow we will be talking about, I am taking the session tomorrow. In that session, I will be talking about principles of arbitration and duties of arbitrator or arbitral tribunal, and duties of the parties, and the consequences of violation of the duties by the arbitral tribunal as well as the parties. We were discussing about these 2 topics of principles of arbitration and party autonomy, basically on the understanding that we have a provision in the Arbitration Conciliation Act, that is Section 19 of the Arbitration Conciliation Act, Section 19 says that the arbitrator is not bound by Code of Civil Procedure and Evidence Act. When the Code of Civil Procedure and the Evidence Act is not applicable to arbitration, how is it that we are going to conduct arbitrations? It is therefore in this context that we were discussing about the principles of arbitration, as well as with special emphasis on parties' autonomy and also duties of the tribunal. The videos will give you a better understanding about the topics already covered. In the Moodle platform, we will be uploading all the necessary information that you may require in very simple terms as possible. For instance, we will be talking about what is arbitration, what is an arbitration agreement, what is the difference between domestic arbitration and international arbitration, what is the difference between ad hoc arbitration and institutional arbitration, and what is the difference between arbitration and litigation, arbitration and mediation, and arbitration and adjudication, and so on. All these details will be provided. Study materials will be uploaded. You will be providing with short videos, and so that you can have an understanding of the basic concepts. And what is expected is every week we will be meeting on a particular timing. At that time, you can raise your questions, and we will try to answer those questions as far as possible. My thought about a career prospects for a law student also needs to be explained. Arbitration gives you a window open to international legal practice. Suppose you are an arbitration professional, you will be able to practice law beyond the borders of this country for two reasons. One is, I have already mentioned that the New York Convention gives a large framework by which the arbitration agreements are recognized by 156 countries, if I'm not mistaken. It should be more. And the arbitration awards are enforceable in all the signatory countries. Second, Arbitration and Conciliation Act 1996 is an adaptation of the model law formulated by United Nations Trade Commission, UNCITRAL. Therefore, if you study Arbitration and Conciliation Act 1996 with reference to the model law, and if you make a comparative study of Indian law with English law, basically this will give you a clear understanding about the procedures relating to arbitration across the world. You need not study about Singapore Arbitration Act, because it is again an adaptation of the UNCITRAL model law. Federal Law 18 of 2018, I believe, of UAE is again an adaptation of this model law. Only one country that stood apart was UK, United Kingdom. So they have a separate law, and it's a very comprehensive law. And we will try to make a comparative study of some of the provisions of the English law with the Indian law. So that will give you a basic understanding regarding the procedural law of arbitration across the world. So it will give you a lot of insight for practicing arbitration law with confidence. These are the few words that I wanted to tell you on this occasion. And I wish you all the best for your studies with the Project Complete Lawyer. And I also wish to that you may introduce yourself so that, and you may also give me a brief input regarding your what we call interface with arbitration so far, so that we can design our program accordingly. For instance, if you have done a basic course, we can think about something advanced. If you have not, if you are a beginner, then we will go with the basics, and we will plan it suitably. We will customize our program accordingly. Thank you.